Truth. Truth is what many people seek, but truth in today's world, as it has been for a long time, is quite rare. It is so rare that there are those who know that truth is being sought by many, and therefore realizes that if only a little bit of truth is taken and then mixed with the complete opposite of what people are looking for, it becomes very marketable because it holds a semblance of what people search for. So long as you mix some sense of gratification into it, even if it's not the truth people are looking for, it is generally known that people would accept that thing. Here is a social media post in one of the groups that pushes certain things that I speak against in this channel ever so often, because these things do in fact have falsehood mixed in between it. Ever so often I implore people, most of the quotes you find online and using ChatGPT actually does not exist in the real court cases. Most people you see starting from around 2023 till now, when they quote you stuff online, they're just going to ChatGPT to search for biases and then they're just copying and pasting it. Let me show you a little bit of example. This is an admin from one of those group. So someone many people trust. And of course, for hypnosis to work, repetition, authority, shock element are three things that are important. If one of those three is continuous, such as the presentment of some form of authority, or just the presentment of repetition, such as that music you don't like, but just keeps repeating in your mind until you finally just go, you know what, it's not that bad. Or something that you weren't expecting that just happens quick and slips through your mind. If one of those three elements are present in anything someone is readily willing to accept, people will easily accept it. One of those subtle subconscious conditioning of authority that causes people to absorb information are during these social media posts when they label certain people as moderator or admin. These are subconscious things that impulsively causes people to accept information without even stopping to say, does this even make any sense, by virtue of it being either actually real reference or not. People don't look at things or question things when those things are handed to them. I implore you, look into it beyond the mundane. There's a huge possibility that whoever posted this, which I'm not going to show their name or their face, because the point here is not about them. It's about the substance. It's about the subtleties involved. It's about the information that people are being misled with. Chances are, huge chances are that this was derived from ChatGPT. I've experimented with ChatGPT so many times within the first few weeks of that thing being public, when they went IPO and they made it available to people. And then I read all of the terms and conditions and I saw the way that it scrapes and the limitation of how it scrapes, and that they hold no liability on accuracy, and that the generative pre-trained transformer, aka GPT, is actually pre-trained to add its own information, even if the information, and especially if the information cannot be scraped, so long as it has a certain fixed percentage of the accuracy. Enters quotes from court cases that most people will take and attempt to use or to validate whatever they're doing. Quotes such as, courts must avoid using the term sovereign citizen as a basis for summary dismissal, as it may lead to prejudice and violate the fundamental right to be heard. United States versus Benaby, 654 F.3D 753 767, 7th Circuit, 2011. In the past, those who follow subtle substance will know how to read this automatically. So when you see someone provide you a quote like this, you already know exactly where to go. I've shown it in several videos such as these. The first few names that you see versus one another is the plaintiff versus defendant. 656 is referring to the first page to which the quote begun, or it can be found within the volume of the record. Which record? It would either be F or P. F stands for Federal Reporter. If it's things like NE and W, that refers to cardinal points like northeast, northwest, which refers to regional reporters, mainly used for state courts. But federal reporters are used for appeal cases. So automatically when you see this F, you know, this is an appeal case. If it's a Supreme Court case, it will say SCT. And 3D that follows this F is letting you know the series within the volume, and all the other numbers that follows it in comma lets you know what other pages within that volume or that court case, such as each page after page, that the words can be found in. 7th CIR lets you know that it's the 7th Circuit of Appeal. And then, of course, the year is the year. These are the basic that people don't know, that when they see quotes, they can quickly cross-reference it to say, this is actually some real shit. Or, yeah, this is just another trash someone is saying because they either copied and pasted it because they heard it from someone who heard it from someone else, or it sounded good and it's just another part of their marketing campaign to mislead people, even though they don't care about misleading people. But just so long as, you know, a lot of people gargle on their balls and people continuously keep rambling on the same nonsense, which is the part that I try to emphasize. Do not ramble the same shit you see on the internet just because someone that you are familiar with says it. Question everything. Use your own deductive reasoning. So now that we know that it's an appeal court on the 7th Circuit, the United States Supreme Court has 11 circuits. The 7th Circuit covers Wisconsin, Indiana, Illinois. So now we know where to go look if we were to go into Pacer, or if we were to go into the Federal Reporter itself. And that 3rd series, we would know to look into the 7th Circuit. That's the first deductive reasoning people should use when it comes to cross-referencing information. And quotes that sounds good, makes you feel good, and backs up that thing that you've been doing for 7, 8, 10, 15 years that has done you no good and has gotten results such as these right here, where someone else, again in one of these online groups, tried all those stuff, all those secure party stuff, and came back and say, look, listen here, I'm not even going to front, that shit doesn't work. Because most of these people have friends who introduced them to one thing and the other. And they came back and said, look, my friend had her DOT plates ran, no driver's license, used a passport ID, quote, private trust. What this quote, private trust means, no one really knows. It's just some word they've heard and some piece of paper they've been told to file because it sounds sophisticated, or to just put stuff in. And they expect all the other parties to have some mega mind Yakub forehead to be able to beam through the space and ethers to go, yes, I see. You have these documents somewhere in your cabinets that validates this. That's right. Yeah, that's true. So we don't know what private trust means. There's a way you can be private without disclosing things, but competence and intricacies and subtleties is how you know how to do it. Car and private trust. What was the result? Got arrested, car towed. So time for court and lawsuits, which most of these people who do secure party run from. Their main goal is to run away from court cases without realizing that's what you're supposed to be going. They've been traumatized that they're trying to do everything else to avoid it. So time for court and lawsuits, which most of these people who do secure party run from. Their main goal is to run away from court cases without realizing that's what you're supposed to be going. They've been traumatized that they're trying to do everything else to avoid it. Yet everything else they're trying to do to avoid it leads them back there because someone has lied to them blatantly, knowingly, insulting their intelligence, and they just accept it because of the sweet gratification that's been given to them. So time for court and lawsuit. Why? Because whoever used the DOT plates, no license, using a passport ID that they've been told to do the silver bullet non-citizen national, even though they don't know what that means and what they consider private trust, at the end, they got arrested, the vehicle got towed. Time for a court and lawsuit. Just keep in mind, if you're going to go this route, you'll be in court and doing litigation. It's not quick and easy thing. This is one woman that was honest and that came back and said, listen here, be careful with this crap. And when those pushing that crap sees it, they come quickly and give you some marketing to comfort you. It's going to soothe you and ease you, rub your back and tell you, no, it's all right. It's okay. Look, they said it's okay that, you know what? Sovereign citizen cannot be used to dismiss anything, because all those methods of DOT are categorized as sovereign citizen. These people have trainings and seminars where they say, if you see this term, these are the categories that you must consider them. Deal with them with impunity. Deal with them like you're at wartime. Deal with them like they're not human beings. Don't listen to them. Make fun of them. Buzzwords such as DOT, such as I'm not driving. I'm not saying all these things are right or wrong. I'm letting you know the objective ground of what's going on as to how you are perceived. The problem is not what you're saying. The problem is the competence that backs what you're saying, because someone like this is giving you fake quotes from actual court cases, which is the falsehood mixed with truth, that says courts must avoid using the term sovereign citizen as a basis for summary dismissal. In other words, he's trying to comfort you. Well, even though stuff would not work if you go to court and you claim stuff that they might categorize as sovereign citizen, because I know I've spent 5, 6, 10 years pushing it onto you, telling you to go do some bonded promissory note, international bill of exchange, give it to the court, ask for their OID, and then if you find something that actually works, make sure you mix that into it also, because, well, this stuff that secure parties do really doesn't really work, and it's well known deep down, but of course it's not going to be disclosed to you. So just jumble everything up. And as you jumble it up as they categorize as sovereign citizen, just know in your mind that sovereign citizen cannot be used as a basis for summary dismissal. Even though none of these secure party stuff has been preparing people for competence of how to deal with courts. And then goes on with his fake quotes, as it may lead to prejudice and violate the fundamental rights to be heard. So now it's mixing procedure, due process, and the Fourth Amendment, which is the right to be heard, and the First Amendment right to speech, which include the right to speak and to be heard. It's mixing it with some fake stuff relating to sovereign citizens to say, it's okay, it's okay. Look, this is a quote relating to the Fourth Amendment. This is a quote relating to the fact that your case can be dismissed if they categorize yourself as sovereign citizen. They then provide you what seems to be the case where it's derived. But if you start doing your research on this case itself, and you look at this exact reference, because this first part means plaintiff versus defendant. This 654 refers to the first page within the volume in the series, and then 753 and 767, the subsequent numbers, refers to anywhere else where it's referenced within the series, which is 3D, and F standing for Federal Reporter, and the Seventh Circuit being the Circuit of Appeal, and the year being 2011. You will go straight to the source directly that's publicly available. And I'm telling you, you will not find this quote. But let's start from scratch, which brings us back here, because these are the basics that most of these secure parties have no idea about, aloof to it. Seventh Circuit, that court case is supposed to be creating some affirmation that it's okay, whatever you use as categorized as sovereign citizen cannot be used as a basis for dismissal, and if they call you a sovereign citizen and dismiss your case, it violates the Fourth Amendment, because, well, it violates fundamental right to be heard. When you speak of fundamental rights, that's the Constitution. So they wouldn't tell you or provide you explanation and clarity that Seventh Circuit only applies to 3 states, because it did not go to Supreme Court. This is the reason why at the beginning of any cases that I read, I always tell you, even if it sounds as though I'm beating a dead horse, I repeat it over and over, tell you this applies in this circuit or in this state, or this is a Supreme Court case that applies to everyone. That's the first caveat. So now if you go into the dockets, let's just say you don't have the time to sit back and click links after the other, and you just want to go straight to the actual case itself and the decision that volume compiled into the 3rd series and the first 654th page in the volume, because you don't want to wait for the PDF to load, and you just want to go straight to the court case and look at that actual court order that's subsequently placed into the 3rd series of the Federal Reporter. You now know you'll be looking into the 7th Circuit of Appeals online docket. So what does that look like? Let's go into it so that you see it for yourself beyond someone else pasting some fake chat GPT quotes that's misleading people and destroying people's fucking peace. Pacer login. All right, let's log in. Search by specific court. Once you log in, you now click your specific court you want. U.S. Appeals Court. We know now that it's from the 7th Circuit. So you go to U.S. Court of Appeals, 7th Circuit. Submit. It loads. It welcomes you. All right. Do you want to file or do you want to search document? We don't want to file. We just want to search the database of the actual court record. So you click that. And wait a minute here. We now need a case number. Did you notice something interesting? Right here. This citation. Whenever attorneys cite cases, they don't necessarily cite the case laws unless the appeal stage. Someone who wants to tell you about a quote should explain the details to you, because these quotes are legalese and it could mean the complete opposite of what you're reading, assuming that the verbiage actually is real and it's not coming out of a rainbow portal farted by a unicorn with a leprechaun to the left with a pot of gold telling you, hey, come get this pot of gold, which is the false promise from the quote. Let's just assume this is real, even though it's all a fairy tale. It's as real as you being able to shit right here, right now on the floor, picking up that shit, smelling it and going, ah, such a beautiful fragrance, and then just licking it like an ice cream. Would you do that? If you're in your right mind, I don't think you would. The same applies with accepting this quote as being real. So we know this quote right here is fairy tale, but let's just assume that, you know what, we are infants. We're minors in the mind, as most people who are secure party will tell you about. Oh, you think you're minors, so you know your parents betray you. Okay, all right, cool. Let's just assume that's what we are. We're dumb, we're stupid, so we say this case is real. If someone is giving you this quote is real, so now someone who's giving you this quote is not even explaining it to you. You don't even know what the case number itself is. If you want to go into the actual case, what you're looking at is just a summary of how it's been compiled for citation on a legal level. Whoever is going to give you this should at least give you the actual case, where this compilation and summary of how they reference it, it's just a citation. Are they trying to hide something? Well, let me show you the actual court case. Remember, this is an appeal case that quote was derived from, and not the district trial stage that quote was derived from. And appeals court cases usually make one or two main decisions as their final decisions, and they don't talk back and forth like the trial acting judges do. This is the actual court document. It is 63 pages. By the time this 63 pages is compiled with other court cases, the reference that you would refer to in that volume in those third series might actually be 700 and something. So instead of us looking at a document that's about 2,000 pages long and trying to find page 700 or something, let's go to the actual case itself before it was thrown amongst a crock pot of many other ingredients. This is the actual case. So what we'll be looking for is the case number. When there are several cases like this, they are usually consolidated. But know that the original case where it came from on the trial stage is 1:03-CR-00090. But the appeal cases, for instance, if it's say a prisoner and they're doing a habeas corpus, they would open the habeas corpus separate from other things such as other hearing regarding evidence in a case. Or if they're doing informal paupers for prisoners, they might open a separate case for that in the appeal level rather than make it into the same case itself. So how did I even get to this document? Let's begin by just looking at one of these case numbers, 09-1190. When you go to 09-1190 and you click it, you see that it is consolidated, aka associated with other cases. So in this particular case, you will see that the reason why it was merged with other cases is because there are different defendants, and those other defendants did their own appeals separately. Defendant Salazar, Defendant Juarez, Defendant Guzman, Defendant Jacinska, Defendant De La Torre, Defendant Perez. So all these other guys did theirs separately. But nonetheless, they realized, okay, it came from the same district. So when we make a decision, we'll just list all those other defendants up here. But as for our friend here in this particular quote, Mr. Bolivar Benabe, that's who we're looking for here. Because when you look at the case citation, it says United States versus Benabe. So he's the particular one that quote was dealing with. If it was with these other guys, it would say United States versus Salazar, United States versus Juarez, so and so. Even though they are the same defendant on a trial stage, but they appealed their situation differently. I hope you're seeing the basics here. The unicorn that got farted out of the rainbow is United States versus Benabe, 654 from the Federal Reporter 3rd series, starting from page 753 and 767. So now we're just going straight to United States versus Benabe. And let's find that particular court order. This is what it looks like. So you see all the other consolidated cases. So when I say consolidated, it just means associated cases. That's exactly what they mentioned it. And that's exactly how they categorize it, consolidated. And as we've read, these are the other cases that the other defendants appealed. So that's their problem. What we're looking at is Mr. Benabe and the issue of the fact that a sovereign citizen cannot be used to dismiss a case, and therefore it violates the right to be heard, which someone is trying to tell you claim a sovereign citizen is somehow protected under Fourth Amendment. I'm not saying it's right or wrong. I'm saying look at the substance, look at the objective reality on black and white right here, that the one making that quote does not want to show you. Case type, criminal. Judgment, meaning it's been closed. Case closed. Okay, cool. Well, let's go look at that case closed. In order for those citations to be admissible, it has to be based on a judgment. That judgment was decided August 18, 2011. Here's another thing. If you don't see this date right here, even though some of the Supreme Court civil rules and criminal rules requires you to put those in a face of document, and then some of the other structures administratively requires the acting judges and their law clerks to put the dates. If just in case you don't see the dates and you're doing your research, just go all the way to the bottom if it's an appeal case, and you would always see the date 8/18/11. In other words, August 18, 2011. But it's very rare for you not to see the date at the top right here, which is August 18, 2011. We go to the docket itself for Mr. Benabe. Terminated 8/18/2011, which is the same date that this case was decided. This is the judgment that's pertinent to be cited if you want it to be admissible, rather than just be something that's going to be ignored. So here we are. We are in the actual case that was first docketed in 2009, and the decision was made in 8/18/2011. So we are taking the time to slowly and gently corroborate the information. USA versus Bolivar Benabe. So what happened on 8/18/2011? Oh, all this happened 2009, 2010. Okay, cool. All right. Wow, that's a lot of stuff going on. Let's keep scrolling. Let's keep strolling. All right. Now we're in 2011. Okay. Whoa. Wait a minute. 8/18/2011. Oh, order. Let's zoom this in. Order. Final judgment. Final judgment. Here's another reason why I'm reading and I'm showing you the actual docket itself. Filed per opinion in non-precedential disposition. Did you know there's a difference between precedential and non-precedential decisions? Precedential dispositions is something you can cite to be admissible to say, look, this acting judge in this particular case, in this particular jurisdiction and venue said this. Therefore, my case is similar, so it favors me. That's precedential disposition. Non-precedential disposition is you can't necessarily cite it and use it, but we're just making this decision here to get rid of something or to come to a conclusion in favor of one party or in favor of both parties. But you can't necessarily cite it to say, here's a res judicata in my favor, therefore act on it. No, that's what non-precedential non-presidential disposition is. In other words, it's not a precedent. What's a precedent? Precedence, the condition of being considered more important than someone or something else. Meaning, if I cite this, what I'm saying, if it's a precedential decision, if it's a precedential disposition, then it is more important than what the other party is saying, because this situation that I'm stating that's a precedence is similar and it's more important than what the other party is saying. Priority and importance, order, rank. But here we are. This case is a non-precedential disposition. So we're just assuming that that rainbow of that quote that we've just read, that came out of a portal that a unicorn farted with some false promises of a leprechaun with a pot of gold. Let's just assume it is true. That's just assuming that it is true. Even if that quote existed, it will be a non-precedential disposition, meaning it's not admissible. It's not considered important. It's not considered priority. It is not considered of something worthy of being accepted as proof, admissible in any type of dealing, privately or publicly. That's just assuming that that quote is real, even though we're not as naive as to assuming it's true. And then what goes along with that order is the explanation, which is the memorandum and opinion. So the order is usually a summary that says, okay, this man won, this man lost, return this, pay him that. It's usually very short, hence 1 page. The opinion that explains why this man won, why this man lost, why you should pay him this, why this should be returned, reversed, or affirmed, whatever it is explained in the opinions, which is 24 pages, which is docket 116. On August 18, 2011. Oh, let me zoom this out. There we go. August 18, 2011, which is this right here. August 18, 2011. The same 7th Circuit in the year 2011. United States versus Benabi. The same 7th Circuit of the United States Courts of Appeal. United States of America versus Bolivar Benabi. Now, let's take that exact quote and just do a basic search engine for it. Let's use Google, because Google is very good and well known for scraping information on the internet. So we type in that exact verbiage. Courts must avoid using the term sovereign citizen as a basis for summary dismissal, as it may lead to prejudice and violates the fundamental right to be heard. United States. Oh, let's make sure we type everything correct, because one letter might make a huge discrepancy in accuracy. And then we type United States versus Benabi. We put 654 F3D 753 767 7 Circuit 2011 as that quote on that social media website shows. Oh, autocorrect. Well, look at that. The only place on the internet that scrapes that same verbiage is on that same group. Courts must avoid using the term sovereign citizen as a basis, blah, blah, blah. So the same place we found that quote is the only place on the internet that could ever be scraped. So now you run into an issue where there's no actual official record beyond someone else's word on some social media platform, Facebook. But you know what? Maybe Google doesn't know what it's doing. So let's just go into the case itself. Maybe this verbiage actually exists. So let's go into the case. Here is the case itself and the actual court docket. So let's go ahead and just paste it. This time, let's remove the reference because it might not be referenced inside the case itself, right? Okay. But you know what? Since we don't find it, let's start looking up the word sovereign citizen. Maybe somewhere in that, if we go through the 63 pages of the decision, maybe we might find that verbiage that, you know what? Sovereign citizen should not be used to dismiss court cases, even if it's not in that exact word for word. So this case in 2011, August 18, 2011, and a decision within that appeal case for United States versus Benaby uses sovereign citizen 4 separate times. So when is the first instance? Let's go look at it. The first instance he uses the word sovereign citizen was in the 20th page of the decision, as follows. After his removal, Benaby filed multiple pro se documents on February 4 that echoed his January 31st assertion of, quote, sovereign citizenship. After Benaby's removal from the courtroom, the authority joined in again saying, quote, I am not a defendant, but I have an unresolved issue that I'd like to address. It was also removed at that point. See, I'm not here to speak about whether what they're saying is right or wrong. We're not even looking at that at all. At all. We're looking at the quote of how people are misled with what sounds good and what they want to hear that ends up destroying their lives. They waste time, they waste monies, they waste just life force of waking up and knowing that issue is in their life because they followed someone's fake quote. I'm doing the research for you. You go do it yourself if you don't believe what I'm showing you, because I implore you not to believe what I'm showing you. So you go look all these things and corroborate it up yourself. So that was the end of that when it comes to the use of the term sovereign citizen, the first use of that quote. The second use of that quote within this actual court order. Let's start from the beginning of this paragraph. True, neither that authority or Benaby behaved in a violent, threatening, or obscene manner. Meaning they were level-headed people, good regular people, just trying their best to be free. All right. They cloaked themselves in politeness, often saying, quote, please, thank you, and excuse me. We're not here to judge whether this is right or wrong, but there's no question that there are frequent and undeterred outbursts in which the defendants declare themselves to be, quote, sovereign citizen. Here is the second instance where this term sovereign citizen is used in a court order that even if it's non-presidential disposition can be cited. That even if that quote that we read from that social media group is not a fart out of a unicorn's butt, out of a rainbow portal, that word sovereign citizen, the second instance it's used, and the reality of the case that it references, is still not going along with the line of the phrase that social media post shown, in which the defendant declared themselves to be, quote, sovereign citizen, quote, secure party creditors, which is the name of that group that we found the rainbow unicorn fart phrase, and, quote, flesh and blood human being, who were somehow outside the jurisdiction of the court, were obstructive, disrespectful, blah, blah, blah. Okay, all right, okay. Now they're saying stuff that makes the other party look bad. That's not what we're here for. What we are here for is that quote real or bullshit? That's the second instance that the court order used the term sovereign citizen. We still haven't found that quote. Let's look at the third instance. Rejecting the shop-worn argument that a defendant is a sovereign and is beyond the jurisdiction bound of the district court, blah, blah, blah. United States State versus Sloan. Okay. United States versus Snyder. Okay, cool. Describing defendant's proposed, quote, sovereign citizen defense as having, quote, no conceivable validity in American law. This is the third instance that the, quote, sovereign citizen has been used. Not just the word sovereign, but the word sovereign citizen. As reported here, when people put quotes on things, they're saying this is where it's coming from. And when quotes with one at its end and the other simply means it's a quote within a quote, meaning this is what the court case is quoting. Courts must avoid using the term sovereign citizen as a base for summary dismissal. We're looking at the actual docket. In the past, I've mentioned people don't go into court dockets and look at it. This is an example. In fact, this case is telling you the complete opposite. It's telling you that sovereign citizen defense has, quote, no conceivable validity in American law. Dismissing jurisdiction argument as frivolous because federal courts, all right, we don't want to rob some salt and injury. Let's move on and look at the last instance that quote, sovereign citizen right here. This quote, see this little quote within this case that is supposed to say this, sovereign citizen. Let's look at it. The last instance he used it. Page 28 of the order. Regardless of an individual's claim status of descent, be it as a, quote, sovereign citizen, a secured party creditor, quote, or a flesh and blood human being. that person is not beyond the jurisdiction of the court. That is the last instance that they used the phrase sovereign citizen. But you know what? Maybe we should just start from the beginning and type courts must avoid using the term. Maybe that's how we're going to find it. Well, what do you know? No such phrase that whoever this is showing you and wants you to believe and lick that lollipop of bullshit. None of that exists in this case. No search engine can find it, but guess what? I'm sure ChatGPT gave it to them though, because it sounds good. And guess what? They're giving it to you too because it sounds good. Before you receive some bullshit quote on the internet by someone that's been telling you about some process that even they will not dare do, they know better not to do it. You should stop for a moment and do some basic research. Start by knowing how to read case laws. Know what this citations mean. Know how to go into the actual cases itself and read the verbiage. Don't let someone looking for some lunch money deter you. But then again, it's your life and your freedom.
They're going to put you all back in chains.
Hey, I'm inviting you to come join the patron page. Not only do you get access to documents, posts, and videos that you will never find on any other platforms, you also get instant access to webinars that otherwise will cost far more. And we speak of things that usually we would not be able to speak of on any other platforms far more freely. On top of that, you get the opportunity to send me monthly questions.